The next item on our agenda should be yes, our youngest member of the Senate joined us because I know he has an interest in it, as well as an older member sitting next to him. Both of them very good in red this morning.
Yes, there, Senator Sparrow.
Senate Bill 2129, relating to virtual currency, adopts the Uniform Regulation of Virtual Currency Business Act and codifies the act into law. So for that measure, we have DCCA.
For a moment, yeah.
Good morning,
Good morning, Iris.
and thank you for hearing this bill. My name is Iris Ikeda. I'm the Commissioner for Financial Institutions, and we have submitted some comments on this particular bill. This is, as you said, the enactment for the Uniform Regulation of Virtual Currency Businesses Act, which was a draft or a model law drafted by the Uniform Laws Commission. We have looked at this for a few years, and in fact, we sent a staff member over to the Uniform Laws Commission meeting to gain some insight as to how they drafted it and their thoughts behind some of the provisions. We did also, after she came back, we did have conference calls with them, to gain additional knowledge as we work through the bill. We have 3 or 4 actually main concerns. One is there are 3 tiers of licensures comprising of a permitted unlicensed activity, registration for a certain level of activity, and full licensure for another level of activity. And we will not have a way of determining which category people or companies will fall into. The second one is that there are a number of exemptions creating uncertainty as to what type of activity is actually covered. The third is that the reciprocity, although we like reciprocity, we know that in the other states there's not a smooth pathway into even the definition of what virtual currency is, and so we would not be, would have to give that a little bit more thought. And then the fourth one is because it's creating a new regulatory program, it doesn't provide for additional staffing for us. Currently, as you know, we are not fully staffed, but in that area, we don't have any staff people. We do have another measure, which we'll talk about later, that will maybe solve some of these issues. But anyway, we offer these comments, and we didn't go into detail, but I'd be happy to answer any questions.
Okay, thank you.
Thank you.
Department of the Attorney General.
I'd have to read the State Commission to promote uniform
Okay.
legislation. Good morning, Chair Baker, Vice Chair Tokuda, members of the committee. My name is Ken Takayama. I'm a commissioner with the State Commission to promote uniform legislation. Thank you for this opportunity to testify on House Bill 2129, which would enact the Uniform Regulation of Virtual Currency Businesses Act, which is, I realize, a mouthful. First and foremost, what this act does not do, it doesn't regulate Bitcoin. It doesn't regulate the values of the commodities or anything like that. It's, in many ways, a garden variety professional vocational licensing regulatory measure with a more exotic than average subject. Part of the difficulty I think that people have with this act, and I will include myself among them, is that the field itself is so new and it's changing so fast, and we don't know which way it's going to go. And that is the reason for the 3-tiered regulatory structure, which in the parlance of the people involved in the development of the act are calling the regulatory on-ramp, because there is no regulation at the bottom levels. Registration, a simple form of regulation, at the intermediate levels where the virtual currency business activity engaged in is between $5,000 and $35,000. and then full-on licensure above that. Beyond that, there are requirements for consumer protection disclosures, such as schedules of fees, disclosures of the extent to which products and services are covered by insurance of one sort or another, and as well as requiring general security features like information security programs, business continuity programs, policies for detecting fraud, and so forth. The intent of the Act is to try to strike a delicate balance between providing the protections that are needed in this area, protections from money laundering, terrorism, financing, and so forth, that it's not used by bad guys for bad reasons, for bad purposes. But at the same time, not stifling the innovation and creativity that comes out of the ferment of the small, unregulated garage operations. It also exempts personal use for yourself, your family, for academic purposes, because that is not where you're doing transactions on behalf of members of the public or people other than yourself. DFI plays a big role in this. The operations cannot be operating unlicensed, registered or exempted, except by action of the division. The division can investigate applicants. The applicants deposit security with the division. And throughout, there are any numbers of places where the department is authorized to adopt rules to recoup expenses, to cover fees, and so forth. When it comes to enforcement, I thought I heard some concern from the commissioner on that. But as far as the unlicensed guys go, if they're really getting involved in doing activities that require a license, it's not worth it for them to try to play around too much, because the division can hit them for fines or for civil penalties of up to $50,000 a day. And by comparison, the amount of revenue that takes you up to the top licensing level is $35,000 a year. So, and beyond that, of course, one of the biggest promoters of enforcement are legitimate entities that have complied with the law and are seeing other guys perhaps skirting the edge. They have every reason to turn them in. So to reiterate, this is basically a garden variety regulatory law in an exotic field, trying to set a delicate balance between public safety, requiring disclosures of activities that could be used for nefarious purposes, but not shutting off creativity, innovation.
Okay.
Thank you.
Thanks, Ken. OIP?
Good morning, Chair and committee members. OIP's concern with this bill is purely with the confidentiality provision. It's a very broadly written one, and one notable feature is that it, in the event that any other state has an even more protective confidentiality law, then that state's confidentiality law would prevail. In other words, if it's confidential in any state, it's confidential in every state. And again, the basic provision is broadly written. I recognize that this was probably an afterthought for the drafters, and in fact, I almost wonder if somebody junior was drafting it, and someone from Bitcoin said, "Oh, we've got some language you can use." But, we would be happy to work with the interested parties if you're inclined to pass this measure out on it. But, again, we do have concerns. And I note that although it's a uniform law, it hasn't yet been adopted by any state. So, we could fix it for the others. Thank you.
Okay, thank you very much. Coin Center? We had some written testimony from this individual, Melody Boutai. Yes, Capital Consulting, sorry.
Sorry, I think that's on behalf of Coinbase, our client, when she
Okay.
sent it in. So Blake Oshiro on behalf of Coinbase, the leading retail virtual currency exchange.
Actually, Blake, you didn't, she just sent in support, but we don't have any testimony. So you're going to need to lead that with us.
Okay, okay.
And you might want to remind your associates that if you're going to send it through the internet, you got to attach something.
Okay.
Thank you.
Okay. Very simply, we appreciate the legislature looking at this. We know that there are two different measures on this agenda. We're in support of both. Coinbase, unfortunately, had to shut down its operations in early 2017. And so whether it's this measure and or the other measure that's on your agenda, we support both because they, in our view, will allow them to continue to operate. I'll be available for any questions.
Okay. I think Coinbase's comments may have come in under the next bill.
Okay.
I see it on my list.
Okay, thank
Okay.
you.
Thanks, Blake. Anybody else here wishing to offer comment on Senate Bill 2129?
Yes. How are you?
Do you have written testimony?
Madam Chair, I do not. Committee members, I do not. I did not find out about this until yesterday,
We
unfortunately.
give everybody 72 hours notice. So.
Yeah.
So
No,
you can,
no, it's okay.
you can turn something in to us, please.
Okay.
Thank you.
I would like to go or tennis, if that's, may I
Pardon?
speak? Or motion on oral argument. I would like to
This is,
speak.
this is not a court.
Yeah.
It's a committee hearing.
Understood.
If you would introduce yourself, tell us
Okay.
who you represent,
Very well.
and then give us something in writing after the
Oh,
hearing. We would
absolutely.
appreciate that very much.
Yes.
Please
No
go-
problem. Sorry for the
please-
confusion.
Please go ahead.
My name is Ian Luthringer. I'm an attorney for the blockchain industry. I represent 12 private digital asset funds, currently working with 6 different initial coin offerings. I've spoken at over a dozen conferences on regulatory framework for the blockchain industry, including initial coin offerings and being able to attach to venture capital and angel investment in the industry. I've also been a securities lawyer, corporate lawyer for one of the leading law firms in the U.S., and my clients included some of the largest financial industry participants that are out there. Anyhow, we have, like I said, I just received this yesterday, and I apologize for not having written testimony, and we will provide that. Our concern overall is that this bill doesn't consider the minority, or I should say, doesn't consider the minority in the sense of economic minority, right? It considers the majority, and I see that you're put off by that right away, but
No,
this
I'm
is,
just confused.
yeah, this is a bill put forward by the ULC, which is a uniform act, and this act has been drafted in part with industry participants in the banking and financial industries. It is not considered anybody who's actually engaged in the blockchain industry. It has some backing by Coin Center, which again is another proponent out of DC, a Delaware corporation that is also backed by the same people who backed the ULC. So it doesn't really consider how is this technology going to be integrated and used to expand economic development and sustainability within various economic centers that it's introduced, such as Hawaii. We all know that Hawaii is not in the best state economically. Introduction of this bill will 100% stifle growth in this industry. People will be leaving here, investment capital will be leaving here. We are also, my group is part of co-founding of the International Blockchain Regulatory Alliance, which its whole purpose was spread across the world We've been forming since this past August. The whole purpose to spread regulation actually helps for the dissemination of wealth across all people and not the concentration of wealth in the few at the top, which has been what we have seen since the Carter administration. Regulation being deregulated to permit the powers that be to maintain this cycle of the concentration of wealth and power. So basically what we're suggesting is at this time that you defer on ruling on this at all. It'd be excellent, and I'm not familiar with Hawaii legislation, so I apologize. But a subcommittee could be formed where there could be real research into this, because we need to introduce the perspective of the actual participants of the industry, and to be able to educate you on what is blockchain technology actually. I mean, you're getting ready to enact a bill that's going to stifle a technology that has the ability to create socioeconomic equality, right? And what this bill will do, it will concentrate the power again in the top, keeping the wealth in the top. All these people here will not reap the benefits of it.
Okay,
So,
you
yeah.
must continue to address the chair and not the audience,
Oh,
okay?
sorry, apologize.
And
And like
you-
I said, I'm not familiar with the Hawaii
I
legislation.
know, but if
rule,
you're going to
so,
come, you probably ought
Yeah.
to get familiar. But
Okay,
thank you
yes.
very much.
Okay, so, and with that, I would say that maybe Mr. Espero and Mr. Chang, if they could be part of some
Senators.
subcommittee, senators could be part of some subcommittee, then we could start to present the proper regulatory framework, which again, we've been working on.
We have another bill that will be looking at some of that as well.
Yeah, the other bill on the, this is,
You can, if you want to speak on the next
Yeah.
bill, you can speak on it when I call it up.
thank you,
Okay.
I truly appreciate it.
Thank
and-
you very much.
Yeah, thank you.
Anybody else wishing to offer comment on Senate Bill 2129? Yes. Hi, JP.
Aloha. I'm J.P. Schmidt, offering testimony as a private citizen. I'm sorry I didn't have a chance to submit written testimony. I will write this down and submit it afterwards. In the interest of full disclosure, I, of course, was the insurance commissioner for the state of Hawaii from 2003 to 2010, and I'm currently an advisor for the Ethereum Foundation, which is the second largest virtual currency entity in the space behind Bitcoin with a $107 billion market cap. I am generally in support of this bill and the next, in that I believe that we need to do something in order to enable exchanges to operate here in the state of Hawaii. As I said, I'm testifying as a private citizen, not on behalf of the Ethereum Foundation, but the importance of the virtual currency is not as important to the Ethereum Foundation, which is more concerned with the blockchain, the underlying technology. And with Bitcoin, the blockchain, the underlying technology simply supports the coin. So they're very interested in the currency. With Ethereum, they're particularly concerned about the underlying blockchain because they've developed a blockchain that can support transactions and smart contracts. And with that, all of the largest companies in the world have been forming consortiums to find applications of that blockchain for them. Some of the most respected advisors in the business area, McKinsey and Deloitte, have estimated that insurance companies that put their internal operations on the blockchain can save 35% of their costs. And that is why, as one reason why they're so excited about it. It provides tremendous benefits. But the coin or the currency is an important part of it. It's necessary for the blockchain to run. And so it's important for the state of Hawaii, I think, to enable exchanges to operate here, in part simply to put out the message that we are interested in new technology and economic development. I don't want to step on Coinbase's testimony, but my understanding is that they are operating in 49 states, and the only state they don't operate in is Hawaii, which is unfortunate. So I really encourage the enactment of one of these bills or something similar, amended, with improvements that may be suggested. I would also suggest that the legislature consider establishing the legislative foundation for a sandbox. And a sandbox is a structure, basically it's like a startup incubator for blockchain and cryptocurrency. United Kingdom has set up one, which has been operating for a while. They recently did a report talking about the lessons they learned. Arizona is looking at setting it up. And again, that will send a message that Hawaii is interested in new technology and economic development, and it will also help in the education about blockchain and what it can't do, and what is good regulation and what is not. Because the regulators work with startups on limited, who operate on a limited basis to see what is going to work and what is not. So I would encourage you to consider that as well. Thank you again. I'll submit something in writing
Thanks,
for you.
JP. Appreciate it. Anybody else wishing to offer comments on Senate Bill 2129? I think since the next item on the agenda is Senate Bill 3082. I'm getting ready to move to that. We'll take what I'd ask for anybody who spoke on 2129. When I call, go through the testifiers that we have for 3082 Senate bill. Ask to, since it's the same topic, just what are the differences if you like this one better than that one, or you want to offer something different. DCCA.
Thank you. Iris Cicada for the Division of Financial Institutions on behalf of the department. So we support this particular measure relating to virtual currency. This one actually is just extending our authority under the Money Transmitters Act, a current program that we have. What we tried to do is to address what we had heard from different applicants about about some of the provisions that we have in our current statute to allow them to operate in Hawaii. The big thing was for permissible investments, and right now the statute only requires cash or something that's like cash. And what we propose is to allow for the like kind. So if you're using Bitcoin, you have to hold Bitcoin. If you have Ethereum, whatever the virtual currency that you want to exchange in, that's what you have to hold. We also, one additional requirement that we are requiring for other companies who also only do internet transactions is an audit of their third-party provider that's actually doing the service for them. Our current applicants have been providing that, but it would be good if we had it in our statute also. Thank you.
Okay, thank you. Ken, do you have any additional comments on the differences between the one we heard and this one?
Well, to state the obvious, we support the previous bill,
I understand.
SB2192. Our primary concern with taking the approach of combining it under the money transmitter statute is that it's attempting to stretch money transmission to cover something that is not money and is not legal tender. Also, that this eliminates the gradations on the regulatory structure that is part and parcel of the previous bill, and sweeps everybody together into one category.
Okay, thank you. Coinbase?
stand in support.
Okay. William Dew. Opposition, Brian Zisk. Good morning.
Good morning. Aloha, honorable senators. I am a small business person who moved about a year ago to the North Shore of Maui. I have been involved in digital currency for almost 20 years, which is quite a while. I helped my friend Bernard Lietaer, the Belgian central banker who designed the euro, write his seminal book, The Future of Money, which laid out all of this. The issue I've been seeing here is that the good actors have not been allowed to operate. So what I've seen is, unfortunately, a large number of consumers who have been wanting to deal with the good actors, but since the good actors have been unable to participate in this marketplace, they have gone with the bad actors and are losing money. What I have seen is when the exchanges were forced out of Hawaii, or forced out of dealing with Hawaii residents, a couple of things happened. Folks were forced to close their accounts, very often being forced to sell. They could have transferred it into their own wallet, which is much tougher for consumers, which is why we want the protection of exchanges. Many people were forced to sell their coins at $2,000 at that time, losing out on the additional $6,000 in upside to this point on each coin. So not only were the consumers hurt, but a massive amount of taxes did not accrue on those gains here to Hawaii. What we see is that there are all the states are running to legislate this because it's a major, major issue, truthfully, with some very good actors and a lot of scammers. And so what I've been seeing is, because the laws here are currently tougher than in 46 other states, as I understand it, I believe there are about 3 other states that also the exchanges won't work with, you have these virtual currency holders who may be unwilling to move here, may feel they have to leave. I have some virtual currency, not a huge amount, but some, as do many folks in this state. If we want to sell it, if we're able to connect to a good actor, they will deposit, they will translate it and deposit it into our bank account. As of now, folks are forced to deal essentially on a black market with something like local bitcoins, where you're finding some local guy and he's handing you cash. That's not what we want. We want it to be no worse, no more onerous than the other 46 states, which protect their consumers by allowing them to deal with these things. So almost to wrap up, when I showed up, I mean, I throw conferences. I threw the Maui Music Tech event here. I threw Future of Money and Technology Summit in San Francisco, where we bring together everybody around the ecosystem. And when I showed up, a very intimidating thing happened to me. People came and they said, "Brian, we know about you. You got awards in San Francisco from the mayor for bringing technology businesses here. And here's what's going to happen. We don't have so much technology internet business here. I raised my kids the best I could. They went to college, they went to the mainland, and they can't return because the technology startups that thrive in all these other 46 states have a much tougher regulatory environment here, and thus they choose not to set up business here, and our kids can't come home." So I understand that regulation is important, but on one side, it's very important to look at the consumers who are involved in this, who need the protection of allowing the good actors to operate. So my only urge is to make sure we're not one of the 4 most restrictive states here, thus hurting the entire state as well as the consumers who are involved in this.
Okay, thank you very much.
Thank you very much. I appreciate it, and I am available because I live here to answer questions on an ongoing basis
Thank you.
for the next 20 years. Thank you.
We have testimony from Ty Robinson. Testimony in opposition. Anybody else wishing to offer comment on Senate Bill 3082? Yes?
Sorry, I was going to
No,
comment on the
if
first one.
you want to come up, you can comment on the topic, state your name, and then give us written testimony afterward.
I submitted it for the first one, but before you allowed it, you kind of moved over to the second bill before I had a chance to comment.
I had,
My name's Nathaniel Harmon.
I don't have you listed on the first bill, so it didn't get submitted,
Well,
or it didn't get picked up. But you're welcome to.
good morning, Chair Baker and members of the committee. I'd just like to state that I think that we should amend the exemptions from the licensee program to include nonprofits, smart contracts, and second layer solutions, like the Lightning Network, the Raiden Network on Ethereum. And yeah, we should bring, business to Hawaii. We've kind of screwed the pooch on, cannabis, and we've been slowly eroding our market share in that business as well, and we're just doing that again. Thank you very much.
Okay, thank you for your comments. Anybody else here wishing to offer comment on 3082?
Well, I'm Shane Shields, Senior Managing Partner of Blockweather Holdings.
Okay.
Chair, Vice Chair.
What was your name again?
Shane Shields.
Okay.
I also submitted testimony on the first bill, but I guess it wasn't picked up. There may have been something going on with the site. We'll submit it afterwards.
Thank you. Please proceed.
I employ 20 people, 20 local jobs. Most of the employees make between $80,000 and $150,000 a year. Good jobs. And my average employee is about 25 to 27 years old. We work with blockchain technologies, and we're here local. A lot of my employees are HPU graduates, college graduates. They're people that want to stay here. They don't want to move to the mainland. Hawaii has a lot of industries, and this is one industry that we should be supporting. This, you had asked us to talk about the difference between the first bill and this bill. On the first bill, we're generally in support of it with a couple of changes, and this one I think is good. The second bill. The first one, the two problems we have is, one, there's an insurance requirement that is it's tough to understand what it is. It's if you go and look for insurance for a blockchain technology company, go shopping for it. And if you find someone that offers it, let me know. It's what is blockchain insurance? What is Bitcoin insurance? Who's offering it? It's hard to find because it's a new technology. So when you say go get unobtainium so that you can become a licensee, it's a de facto ban, and that's very dangerous. The second thing that's very dangerous about it is that about the first bill versus this bill is the first bill says you can submit an application, but in 30 days if you haven't heard back, you must immediately cease operations. What does that mean? Does that mean that if you're invested in ICOs and you have $1 million out there, or 10 or 50, where does that money happen? What happens with that? It's very dangerous. It's dangerous to have a law that says, if you apply to be a bus driver, but at 30 days, if you haven't heard back from us, on day 29 you're okay, but on day 30, take your hands off the wheel. It's dangerous. And I strongly encourage you to look at those parts of the bills in the first one versus the second one, and that's why we're out in favor of the second one. But we could be in favor of the first one with those changes. Thank you.
Okay, thank you very much. Members, any questions? If not, we'll go to the last bill on the agenda. Okay.
Sorry, hello. Thank you once again. My name is Sean Boyd, again, a private citizen, and I will submit testimony written afterwards. I just want to say, as a private citizen, the biggest confusion stands as follows. In portions of the bills, they speak of cryptocurrency as if it's a cryptocurrency. In other portions, where language fits the conversation, it switches to talking about money. And so at some point, the definitions are confused even in the two bills as they sit together. Partially says money, partially says not money. The other problem that seems to be is, like you said, the gentleman mentioned, when Coinbase was told to remove, and I got the email that said I had to remove things from my account, I went looking for places, and the best I could do is place money off seas, or, in an exchange overseas where there's less protection than the protection I had out of a U.S.-based company. So instead of protecting us, which was the initial, I guess, sort of intent, we ended up moving to places that could potentially become bad actors. And some people recently got caught up in the BitConnect problem because of having to move to, a different exchange because you guys said we can't have Coinbase. So if the goal is to protect us as a consumer, then you're not necessarily protecting us if you're forcing us who want to invest to go to somewhere where it might be, additionally dark. And I guess sort of the last thing is, this was similar to what happened with the medical marijuana industry and other industries like that. In the idea of protecting someone, you send them to the dark alleyway to do a sort of scarier transaction. It's making it worse. And from a consumer standpoint, the feeling amongst my contemporaries is that the traditional financial institutions came in and scared you guys so that they could stay in the business. And that's not accusatory. That's the sentiment amongst my circular friends. We have a large crypto forum for Hawaii with a bunch of members in it. So if the goal is to protect us, we have to work on our definitions. We have to make sure we're not creating policies that are tough to enforce or cannot be enforced, are so confusing that people attempt to even more so skirt the regulation. So I'm begging you guys to, if we want to do something reckless with us, our money, hey, that's on us. You don't really have to protect us. We're adults. But B, if we're going to do it, at least talk to people who are in the industry who can help the verbiage so we don't pass laws that really cannot be enforced or would send someone into further harm.
Thank you.
Thank you.
We'd appreciate if you want to reduce some of your comments to writing so we have it for the record. Anybody else?
Madam Chair, very quickly.
No. Haven't you already spoken on this measure?
Madam Chair, not on this one. Thank you.
Okay.
Committee members. Yes. So I would just like to point out that cryptocurrency is actually not just a currency. It's not a commodity. It's not a security. It's not property. It's all of them. That's why there's so much discrepancy in how it's being regulated at a federal level. With this bill that's currently enacted, it's trying to regulate it not only as a currency, but as a commodity, as a security. It's taking that all and playing it in. It's trying to regulate investment brokers, which would normally be regulated under an Investment Company Act. It has too far of a breadth. It really just needs to be revised. We're more in support of the first bill with revisions that, have more favorable constituent parts to the masses. But this one in itself is inappropriate as it does have overbroad scope. Thank you.
Okay. Anybody else? All right, let's move on. To the last.
Are we able to take questions?
Sure.
I just had some questions for
Okay.
Commissioner Kedem.
Sure. Iris, Senator wants to ask some questions.
Hi.
Thank you, Commissioner, for all of your hard work on this issue as the administration's expert on it, and your testimony that I thought was very helpful in both of these bills. Could you just sum up how many states have adopted the approach of the first and how many have adopted the approach of the second?
Okay, so before I begin, I'm not an expert. I'm far from an expert. We're still learning. The first, the Uniform Laws Commission, so far no state has adopted that. In the second one, changing the money transmitters, that's how states have, except for New York, that's how states have been going along and trying to supervise this particular industry. I would say not all states are supervising this industry. There are some states that have said we don't recognize virtual currency at all. And I think that's what they're talking about as 46 states being regulated. There's really only maybe less than half are actually being regulated or supervised by the banking departments. The rest of them, I think, either are not being recognized in the state or there's a specific exemption in their law that says it's not recognized.
So in other words, in most states, there's absolutely no regulation of cryptocurrency whatsoever?
I wouldn't say most states.
The plurality of states?
I don't really know. Would have to go through each state.
How many states adopt the second proposal under your proposal, the second bill?
So the way that the changing the permissible investments, so that's where states are going, is changing the permissible investments to either go 1-for-1 on the virtual currency or a percentage of real cash and virtual currency to back up the transmission. I don't really know the percentage of that. There's no clear pathway as to how states are, supervising this particular industry. We do like innovation. When I started, I'd just like to say, when I started in 2011, we only had 39 money transmitters. We have, kind of opened our doors and said we want innovation. We now have 96 money transmitters who are doing a variety of different methods of money transmissions, some of which had been doing Bitcoin exchanges until recently when the exchange rate or the valuation became really high.
Commissioner, are you aware of any legitimate licensed money transmitters that Hawaii consumers can today use to purchase and trade these cryptocurrencies?
So there were a couple that were doing these exchanges. I don't want to name them. I don't know if they're currently doing this. They don't report, on an ongoing basis what they're doing. But we had seen through previous examinations or filings with us that they had been, doing some of these exchanges.
Well, we heard testimony today that Coinbase, which is a very well-known one, has pulled out of Hawaii as of a year ago. And so if, in fact, as we have heard in testimony, that there are no legitimate exchanges today, is there a legal way by which Hawaii residents may buy and trade cryptocurrencies?
So let me just say, we normally don't talk about any applicant that has pulled out, but Coinbase has made it pretty public. They voluntarily withdrew their application. They were an applicant. We told them what the requirements were. They chose not to comply with the requirements that we have as part of the law, and they chose to withdraw. They then told all of their customers to sell all of their whatever they're holding. We did not order any of that.
Okay, so let's...
We do actually have three, I checked this morning, we have 3 applicants still in the queue, kind of waiting to see what the law, we have told them that we are, trying to change the law, and so I think they're going to wait to see what happens with the law and then go forward with their applications.
So let's say I'm a Hawaii consumer today, I'm a Hawaii resident, and let's say I go on Coinbase or another site that might be offshore in a different country, and let's say I want to trade and buy cryptocurrencies, and let's say I input an address of a friend who lives in another jurisdiction and buy and sell cryptocurrencies in that manner. Is that legal?
So we wouldn't know anything about that. I mean, we only supervise the licensees or applicants that apply to us. We do look at unlicensed activity. I would say that no one has complained about doing that. We don't offer any legal advice on whether or not people should be doing that. There are folks that are currently holding Bitcoin in particular because, as I said, these exchanges had been operating. So I think they're still holding them in some manner.
If someone were to provide you with evidence that these companies were doing business with Hawaii residents who may have fraudulently misrepresented their addresses, would that be against the law?
The consumers, you mean? We wouldn't go after consumers.
What about the institutions?
We
exchanges?
supervise companies. Yeah.
What about those? Would they be?
We would investigate.
Okay. And then just one final question, Madam Chair, and that is, in your opinion, Commissioner Ikeda, are both of these bills better than nothing, or is only the second bill better than nothing?
So we would prefer the second bill because we already have a program called Money Transmitters. We have a lot of consumer protections already in the money transmitter laws. What we were trying to address is what our applicants have been telling us, which was they could not meet the requirements of cash or cash-like. And so that's the part that we were trying to address for the license or the applicants that are currently in our queue, our application.
Is the first
queue.
bill better than nothing?
The first bill, we prefer not to have the first bill.
Thank you. Thank you, Madam Chair.
Okay, thank you. Any other questions, members? If not, let's go to the last bill on our agenda.